look like moving forward? We are going to be checking in momentarily with our attorneys who are joining us here with expert answers. Right now, though, let's go ahead and check in with JR. He is in our other studio right there answering those questions. Hey there, JR.
Hello there. Attorney Dayne Phillips is joining us now to talk about his reaction to what happened with the state Supreme Court. Now, we've been talking about this pretty much all afternoon, but let me just go ahead and get your initial reaction to hearing there is going to be a retrial here.
Well, it was the right decision. The South Carolina Supreme Court made it clear that our system of justice demands that every person, and the court's opinion emphasized the word every person accused deserves a right to a fair trial by an impartial jury.
And the focus here on Becky Hill possibly tampering with the jury. She continues to deny those claims, but that apparently played the bigger role in the Supreme Court's 5-0 decision here than the admittance of financial crime evidence, right?
That was the critical point. The conduct that she says did not happen is the conduct that she absolutely participated in that resulted in the reversal of the conviction.
And the financial crimes, they did mention those. I thought the defense team played up the financial crimes, saying they should not be allowed into evidence in this case. And at the end of the day, the state Supreme Court says maybe not so much should have been allowed. What does he mean by that?
So it's limiting the scope. In other words, the South Carolina Supreme Court said that they went too far, that the trial court allowed them to go too far, that the financial crimes were admissible, but the context of them, one specific example highlighted in the opinion was that it went into the testimony of the individual being a vulnerable adult, and all the specifics that are unrelated, not relevant specifically to the murder charge itself and proving the murder charge, or as to the motive part of why the murder would have happened. And so the financial crimes part of it, the court decided for the new trial to give whoever the new trial judge will be the guardrails, so to speak, of saying, look, it went too far. It must be narrowed in scope.
The State Attorney General's office just a short time ago saying they hope to retry this case by the end of the calendar year. Is that doable?
I don't believe so. I would be completely shocked if they were able to have this case tried before the end of 2026. I understand it's still fairly early, it's the spring, but coordinating that amount of witnesses, the just internationally known high-profile nature of this case, so many moving parts from the state's significant number of witnesses. This was the longest trial in South Carolina history, 6 weeks. And so when you have that plus the expert witnesses of potentially the defense, I think it's very unlikely.
And if they do have a retrial before the end of the year, does it stay in Colleton County?
So ultimately, the answer would be yes, unless a side makes a motion to change venue, and then the trial judge, whoever gets assigned to that case, grants that motion.
All right, well, appreciate your input on all of this tonight. Thank you so much. If you'd like to give us your say, you can do so. You can text us at 803-776-9508, or you can go to our Facebook page and give us your question or your reaction to today's decision by the state Supreme Court.